23 years. That's not just a number. For one family, it's a constitutional battle that has spanned, well, an entire generation.
It really has.
And today, we're breaking down the legal strategy behind a massive writ petition filed in the Telangana High Court.
The petitioner, Shri G. Vishnu Sharma, is fighting the state and the Human Rights Commission over a compassionate appointment.
An appointment that stems from his father's death 23 years ago.
And our mission today is to unpack how the petitioner's argument tries to turn that two-decade gap from a deal-breaker, the state's main defense, into the core evidence of administrative failure.
Okay, so let's dive into that first major hurdle, the Telangana State Human Rights Commission, or TSHRC.
Right. They refused to even hear the case.
Why?
They just looked at the calendar. They saw 23 years, and they invoked Section 36(2) of the Protection of Human Rights Act.
Which basically says...
It's a time bar. They basically said the clock ran out, case closed.
But that's not where the story ends. The petition has a powerful counter-argument.
A very powerful one. It pivots completely. It claims this isn't about a one-time event that's now expired. It's a continuing violation.
A continuing violation of what?
Of the right to livelihood, which is, a fundamental right under Article 21.
Okay, so here's why this matters to you, the listener. If the court accepts this argument, this continuing violation idea...
It changes everything. It means the court has to look past the calendar. It overrides that time limit and forces them to examine what the administration actually did, or rather didn't do, all those years ago.
And when you start looking at what they did, it seems the state ignored its own rules.
Oh, absolutely. They disregarded their own binding rule book, which is called Geo Min's NOP 60.
And what's the key mistake there?
Well, the first big one is they ignored Rule SL 16. The scheme flat-out mandates age relaxation for the deceased's spouse, in this case, Espoji Pavani, if her children were minors at the time.
Which they were, back in 2003, 2005.
Exactly. So when the state later rejected her, saying she was over the age limit, that rejection was basically illegal.
Yeah.
That protection was mandatory, and they just ignored it.
And there was another problem, too, right, with the initial job offer?
Yes. This is what the petition calls a constructive denial.
A constructive denial.
The first job they offered her back in 2003 was for a nursing orderly post, but it came with mandatory night shifts.
A tough situation for a widowed mother with young children at home.
It's more than tough. It's a poison pill. It forces her to choose between caring for her children and taking the job. The petition argues that this defeats the entire humanitarian purpose of the scheme.
But the state's biggest defense, as you said, is still just the passage of time. They're basically saying the family waited too long.
And this is where the petitioner's documentation becomes the smoking gun.
So what do they have?
One key document. On May 9, 2007, the family submitted an officially acknowledged, notarized, no objection affidavit from the daughter.
Okay, and why is that piece of paper so important?
Because the state required it to proceed with the application for a different post, a junior assistant.
So the family did their part.
In 2007, they did their part, and then nothing. The administrative negligence is the near decade of silence that followed. The file just sat there, unprocessed, from 2007 until 2017.
So the administration created the delay.
And then used that very delay as the reason to deny the family relief. It's an incredible catch-22. The petition argues that this makes the final rejection arbitrary under Article 14.
So after all this, what does the family actually want the court to do?
Two very specific things. First, a writ of certiorari, basically an order to quash, to erase the Human Rights Commission's order that said it was too late.
Get rid of the time bar.
Exactly.
Yeah.
And second, a writ of mandamus. That's an order to force the state to re-examine the case and approve the appointment for the son, Shri G. Vishnu Sharma.
This whole deep dive really shows that sometimes the difference between justice and, well, permanent rejection.
It can all hinge on one ignored rule, like that Rule SL 16, and one forgotten piece of paper, that 2007 affidavit.
So here's a final thought for you. What does this case tell us about the immense power of persistent, detailed documentation in securing your constitutional rights, even when you're fighting against decades of silence? All right, let's unpack this. Today, we're diving into a really powerful real-world case. It just lays bare how bureaucratic delays can, well, deeply impact a family's life, stretching across decades.
Yeah, decades. It's quite something.
Our mission today is to trace the journey of this compassionate appointment application. See how a system that's supposed to be a safety net can sometimes, become a source of immense hardship instead. We're looking at the story of Savina Ganti Pavani. Her husband, Shri G. Krishnamurthy, was a sub-inspector in Hyderabad. Tragically, he died in the line of duty back on February 3rd, 2001.
A really stark beginning.
Yeah.
And what's striking, from the sources is how quickly the family acted. Sana Pavani applied for that compassionate appointment on March 19th, 2001,
Oh.
literally weeks after her husband passed away. You'd think that kind of promptness would help things move along.
You would hope so, right? But here's where it gets, well, complicated. The first twist comes in 2003. She was offered a nursing orderly post. But here's the thing. Her educational qualification was an SSC, that's the secondary school certificate. Basically, high school.
Right.
Which, under the rules at the time, these government orders, GOMs not paid 5, 77, and 87, actually made her eligible for a junior assistant position. A clerical role.
Not the Class OV nursing orderly role they offered. So a clear mismatch right out of the gate.
Exactly.
And then it gets even worse. When she actually tries to join in 2004, the hospital turns her away.
Why? Did she refuse?
No, not at all. The reason given was no post available. It wasn't her saying no, it was a system issue.
So they offered a post that didn't exist, or at least wasn't open.
Seems like it. And crucially, the department itself realized this mistake. They actually recommended her for the correct post, junior assistant, in 2005.
Okay, so correction made. Finally.
Yeah, documented too. Proceedings number A46169, 2004. This really should have been the point where things got back on track.
But it wasn't, was it?
No. So at this point, we're in 2006. Samba Havani is 46 years old. Her son, Sriji Vishnu Sharma, he's still a minor.
Okay.
She submits her acceptance for the junior assistant role, all the required documents,
Yeah.
and then nothing.
Nothing. The file just stalled.
Completely stalled. The sources suggest it got bogged down in, unresolved jurisdictional issues. Apparently, Malkajiri, where this was relevant, was in a different district or something administratively messy like that.
So a boundary line change or some red tape like that basically froze her application. For how long?
Well, picture this. The process just stops. It's radio silence until 2017.
Wait, 2017, that's 12 years later.
12 years. And then her son's application, because by now, time has passed, his application is suddenly rejected.
Rejected. Why?
Because of an upper age limit.
But hold on. That age limit issue only came up because of the department's 12-year delay.
Exactly. A direct, devastating consequence of their own inaction. It's unbelievable.
Unbelievable is right. And today, in 2025, where does that leave them?
Well, Sankanti Pavani is 66. She's well past her retirement age now. Her son is still waiting, still caught in this.
And the financial hit, it must be staggering.
Oh, it is. The estimates we've seen suggest anywhere from 1.15 to 2.3 crores of lost salaries alone.
That's millions of dollars equivalent.
Yeah.
Yeah.
Plus another maybe 25, 30 lakhs in lost benefits like pension, gratuity, not even counting the family pension she should have received or the employee health scheme access. Critical stuff.
Wow. When you look at that whole timeline, the initial errors, the 12-year stall, the final rejection, what really jumps out at you? How does a seemingly simple administrative oversight just snowball like this?
It's a profound system failure, really. It shows how disconnected parts of the bureaucracy can become and how easily a life can fall through the cracks.
So what does this all mean then? This case, laid out in the appeal documents, it's not just some file number. It feels like it's about a family's, their right to a promised safety net that just got tangled up, lost in this administrative maze.
Absolutely. And the core argument is pretty straightforward.
Yeah.
The delay wasn't their fault. It was entirely on the department's side. And that's where the legal precedents come in. You mentioned cases like Umesh Kumar Nagpal and Uma Devi, T. Rama Devi. These are important. They basically establish that these kinds of administrative delays shouldn't end up penalizing the grieving family.
So the law actually anticipates this kind of problem.
It does. Often these rulings specifically say you should consider the dependent children if the original applicant, like Samal Pavani here, ages out because the administration just didn't act. The framework is there to prevent this exact scenario.
Okay, so the ask now, the current request, is essentially to honor that original 2005 recommendation, the one for the junior assistant post.
Precisely. Take that file about A46169 2004, consider it valid, and transfer the benefit of the compassionate appointment opportunity to her son, Sriji Vishnu Sharma.
It's not asking for something new, it's asking to complete what was started, just redirected because of the time lost by the system itself.
Exactly. And it really makes you ask, when the systems designed for compassion fail this badly, purely because of their own internal processes, what's the real cost?
Yeah, it's not just the rupees and lakhs, staggering as they are.
No, it's the human years, the lost opportunities, the the erosion of trust, really, in these public institutions.
It's a powerful reminder. Compassionate appointments, okay, maybe they aren't an absolute right in the legal sense, but the process, the integrity of that process that handles them.
That has to be solid, because when it fails, the impact is real, and it can last, as we see here, for generations.